file 23-21641-FH and 23-21642-FH, People versus Cody Charles Eichler. We are here today for a pretrial conference in both of those cases, and we are proceeding today by video conference and in person. Let me first ask the attorneys to place their appearances on the record.
Phoebe McClure on behalf of People.
Senator Michael Dagger Margosian for Mr. Eichler.
And sir, you are Cody Charles Eichler?
Yeah.
All right. Mr. Dagger Margosian, where do we stand with Mr. Eichler's case today?
Your Honor, we do have a plea and sentencing agreement. The plea will be that Mr. Eichler is going to plead guilty to 1 count of felony firearm and 1 count of felon in possession. And in exchange for that, the remainder of the charges on the other files, as well as the habituals, will be dismissed. Regarding the sentencing agreement is that Mr. Eichler will serve the mandatory flat 2-year MDOC sentence of the felony firearm charge, and that the felon in possession sentence would be credit for time served. So in other words, the complete sentence of this case would be the flat 2 years. As we discussed off record in a bench conference, Mr. Eichler is on parole. There's no agreement as to what would happen with that. That's obviously outside of our jurisdiction. That would be handled by MDOC.
All right, Ms. McClure, is that a complete and accurate statement of the agreement?
So I don't mean to, I guess, throw a wrench in it at all, but I've not made any agreement as for the tampering to be dismissed. I thought he was going to be pleading to the tampering.
No, it was a dismissal of all the files and cases except for these 2 charges that he's pleading guilty to today.
My agreement was for dismissal of the other firearm case, not for the tampering case.
My notes indicate that it was all offenses and all files other than these 2, so it did include the tampering charge.
I mean, I guess if he's not going to plead to it, I don't know if we need to do something else, but that's not my agreement.
Well, all right, I guess we're in disagreement.
My notes say that he will plead to it, but before that, my notes as far as the offer goes is that it would be a concurrent agreement with it.
No.
All right, so apparently there's been a misunderstanding between parties as to what offer was made and or what offer was accepted. How do you want to proceed from here, Mr. Dagger Margosian? Do you want some additional time to discuss issues, or what do you want to do?
Well, yes. I mean, I'll speak with Mr. Eichler in a second. He's waving his hand right now, but
It's all right. It's ran concurrent. I'll plead to it. It don't matter. As long as the time it's still concurrent.
if the
All right, so can we just hold on 1 second? So Mr. Eichler, there's a really bad echo in that room. Could you try sitting a little closer to the device, because it's really difficult to understand what you're saying? And before you say anything further, do you want me to put you in a breakout session with Mr. Dagger Margosian so you can speak to him privately?
Thank you.
And before we go in there, let me just make sure that if the sentence of putting aside what we thought we had agreed on, if the sentence of this tampering would also be a credit for time served, in other words, it doesn't increase the sentence more than the 2 years, then I need that to be understood as well.
I would make a sentence agreement that is concurrent with the other felony.
With what felony? The felony firearm? It can't be. That's my trip right now. That's what I'm getting tripped up on.
With
Well,
the felon possession.
The felon in possession is going to be a credit for time served, because that's the only way it can't be. That's the only way the 2 years wouldn't be increased. So if it's a credit for time served sentence on both the tampering as well as the felon in possession, fine.
I guess I'm confused. I apologize.
All right, why don't
Your Honor,
we,
could I maybe speak with Ms. McClure? I don't want to delay this case anymore just because this is dead time for Mr. Eichler. So can I just have a moment to speak with Ms. McClure if possible?
don't know that I have any way for you to do that privately. Ms. McClure is in the courtroom today because she was having a technical issue with her device being able to access Zoom, so.
Well, I can just call her that way. I mean, I just want to make sure everything is smooth.
I'm not sure based on what I've heard here today that it is.
I understand. I agree.
If you want to call her, I can give you a couple minutes, but I've got, I need that jail room for other cases that I have people waiting on, so it needs to be quick.
Understood.
Could we just do a week, Judge? Would you be able to bring us back 1 week?
Well, I've already been prolonged like months, but like my case has already been pushed out.
Hang on.
Mr. Eichler, please stop.
This is
I just don't think the conversation's gonna be quick.
Crazy.
Or even tomorrow late morning.
No, I don't want myself.
I can send it over. I can send it over until Mr. Eichler, please.
Judge, maybe tomorrow, if tomorrow.
Mr. Eichler's device because he is being disrupted to the court process. I can set this over until tomorrow. Let me look quickly. So I can set it for tomorrow morning at, I can either do it along with sentencings at 8:15 or do it shortly after that.
Your Honor, I'd prefer, I have a few bond hearings tomorrow morning at 9. I'm wondering if it could be after those, around maybe 10-ish or so.
Ms. McClure, are you available at that time?
I'm available.
All right, so I can do it tomorrow morning at 10 a.m.
And Mr. Hager-Margosian, I'll call you after court this morning.
Okay, thank you.
All right, so we'll set it over for tomorrow morning. Mr. Eichler, you can let the officer that's with you know that you've done with court for today. Okay, you don't call for Mr. List. Mr. Bolero, we do have Mr. Jenkins here. Do you need a breakout session with him?
Can we call the Lester, please? Lester.
Let me pull that file up, Judge. I think we have a plea on that.
Okay.
Yeah, Judge, we're close to a plea, but I didn't follow up with Mr. Hartung to make sure all the details were nailed down.
Sam, I emailed you, I realized you had some problems going on, so I emailed you this morning amended information for both plea options.
Oh, okay.
So you have that, and I have a copy here for the judge when you tell us which one you want to do, if you want to do it today.
Yeah, sorry, but I don't like to make snap decisions, so could we just adjourn it? And then bring it in? I'm sure we'll probably bring it in next week for sure. I just want to look at them over and not make snap decisions.
Okay. I will bring in Mr. Jenkins and can do that on the record.
Sorry.
No problem.
Okay, we are on the record in file 22-21198-FC. People versus Dakota Brian Jenkins. Mr. Jenkins, is there a television or radio on in your, wherever you are? If there is, I need to have it down.
Yeah, 1 second. Can you go in the back room or something? Okay. All right. Should be off.
All right. So we're here today for a pretrial conference. We are proceeding today partially in person, partially by video conference. First, let me ask the attorneys to place their appearances on the record.
Doug Harton, appearing for the people.
Salvatore Malero on behalf of Dakota Jenkins.
All right, and we've had a brief discussion of this case off the record. It's my understanding, Mr. Malero, that you now have some kind of alternate offers and you want to take some time to consider that, discuss it with Mr. Jenkins. Is that accurate?
That would be accurate.
I already have a full schedule for next Wednesday, but I can do February 7th if that works for everyone.
That's fine, Judge. If we get it resolved earlier, could we come in on an alternate date?
Yeah, that would be fine if you want to contact Francis and can figure out a.
Okay, that'll work good.
I don't know what we've had some, well, actually next week we're going to have a trial, so.
That's fine.
All right, so we'll set it for February 7th at 8:15. Mr. Malero, could you do that stip in order?
Yes, Your Honor.
Okay. All right, Mr. Jenkins, then you are all set for today. You can go ahead and log out.
Thank you.
Thank you, Judge.
All right, Mr. Lester, the device at the jail is muted, so I'm going to send a request to unmute that. And then Mr. Dagger Margosian, did you need a breakout session with Mr. Lester?
Yes, please, Your Honor.
Okay.
Judge, there might be a plea on this young matter. I think Sam's gonna have to confirm it. He went over to the jail last night after our motion.
Okay. All right, we are on the record in file 23-21516-FH, People versus Donald Raymond Lamont Lester. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference and also in person. We are, or first let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
PB and McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Lester.
All right, and Mr. Dagger Margosian, where do we stand with Mr. Lester's case today?
Your Honor, at this point, I don't, there's a breakdown of attorney-client relationship. I can't move forward and represent Mr. Lester. I've, without getting into the details, obviously those are privileged, but it's clear that Mr. Lester either needs to move forward pro se, and I can certainly be on standby, or I can conflict this out, but our office is not going to be able to represent Mr. Lester.
Yeah, I would like the ACLU to report. I poured everything to the ACLU. They already have my file and the Civil Rights Commission.
Mr. Lester, I'm sorry, but the microphone at the jail is really bad. There's a bad echo there.
Can you hear me? Can you hear me now?
Yeah, so I can hear you. The issue is if you could talk not quite so loudly, because it's an echo in the room that causes the problem.
I'm moving the ACLU and the Civil Rights Commission already are on this. You can move my file to those. I have sent them my complaints. I've also got the failure to appear, what I was picked up for in the first place, was dismissed. And Mr. Margosian is trying to move forward with a trial, and I'm not feeling that. I want to move for an immediate dismissal because I was harassed for 3 days, and they already have wind of this. There should be they should be asking for the body cams from August 2nd, as well as the 4th. I still haven't went over any evidence. So the Civil Rights Commission has my paperwork, and my affidavits rather, and the ACLU is on standby as well. I just rather for my whole file to go to them and let them represent them, let them take a look at what's going on. I don't have any transcripts. I haven't talked to Ms. Margosian since then. I had to have the jail email the courts for a court date because I've been sitting here for so long. Like I said, the failure to appear got dismissed. That's what I was picked up for originally.
Okay, so Mr. Lester, you've been charged with possession of methamphetamine and 2 counts of assaulting, resisting, obstructing a police officer. You have previously been represented by the public defender's office, and they are requesting to withdraw as your attorney at this point. If that were to happen, another attorney would be assigned to you.
I just said the ACLU. I don't know what part of that nobody understands, but the ACLU is on standby as well as the Civil Rights Commission. I said it again. You can forward that all over there to them, and they'll take the case without no money. You know it like
all right.
I know it.
So Mr. Lester, that is not an option that I have, to send this case over to the ACLU. If you want the ACLU.
I do though, I do though. So let's get that understood. Now I have that opportunity to do that, and I'm requesting that on record.
Okay, you can request that, but the court is not in a position to do that. If you want someone else to represent.
I am, sir. That's what I'm trying to tell you. It's not simple as you just putting the case together and sending it to them. It's not even you. Mr. Margosian can do it. It's not even your office that needs to do it.
Mr. Lester, please don't interrupt me when I'm talking to you.
Right. Here we go.
All right. Right now, the public defender's office represents you.
No, they don't. He just said he didn't want to represent me.
All right, Mr. Lester is off camera. I don't know whether he's still in the room.
I'm standing right here. I can hear every word. I'm here as a third-party intervener and a special appearance.
All right, Mr. Lester, are you in agreement with Mr. Dagger Margosian's request to withdraw from your case?
That's on him. Like I said before, I wanted to go to the ACLU or the Civil Rights Commission. I'm going to say it again for the court of record. They are on standby. They already know about all of this. I shouldn't have never been picked up in the first place. I was harassed for 3 days. 3 days. And you have the transcripts right there in front of you when the officers admitted that they just wanted me. And it's in the police report.
Mr. Lester, I need a yes or no answer to the question of whether you are.
Again, that's on him.
Mr. Lester, I've muted your device, Mr. Lester, because you are being disruptive and you are not allowing this court process to continue. I'm going to give this one more opportunity. I'm going to unmute your device. I'm going to ask you the question. If you don't answer, or if you continue with this disruptive behavior, I am going to hold you in contempt and sentence you to 93 days in jail.
Very unprofessional.
Mr. Lester, are you in agreement or are you not in agreement with Mr. Dagger Margosian's request to withdraw as your attorney?
Well, if you please, yeah, I'm in agreement. Okay? If you please send that file over to the ACLU, please. I'm in agreement with that. Mr. Margosian, are you in agreement with you send that over to the ACLU, please?
Can I get like a contact information? I mean, I don't just send a file to
You
the
know,
ACLU.
okay, yeah, but you know where the ACLU office is. I can get that to you. Yes, no problem. We can go off screen. I can get that to you. I have it right here in front of me. No problem. No problem.
And if that for whatever reason, I mean, that's outside the norm of
Man,
what
I'm not. It's as simple as
All right.
saying my rights have been violated. You know that. We're not going to keep going back and forth. I'm not
All right,
doing
whatever.
it.
All right.
I'm tired of this.
Mr. Lester, please stop. So Mr. Lester has consented to Mr. Dagger Margosian withdrawing as his attorney. If there's some arrangement for Mr. Dagger Margosian to send information to the ACLU, that is, court has no control over whether he is going to do that, and the court has no authority to require him to do that.
And Your Honor,
What the court is required to do under this process is to provide for the appointment of a special public defender. If Mr. Lester can get the ACLU to represent him, then you need to make arrangements to do that. And if there's an appearance filed by the ACLU, then they are welcome to represent him. But as it stands now, he is without attorney, and the court will make the appropriate arrangements to have a special public defender appointed. If the ACLU wants to substitute in place of that person, they are welcome to do so.
Yeah. I also like for a PR bond. I've been sitting here almost 180 days. My bond is ridiculous. My family's not going to be able to pay that.
All right, I will adjourn this case to February 7th.
I'm requesting a bond, please, for the court of record.
Mr. Lester, let me do one thing at a time. You're constantly interrupting me.
I'm just tired, man. I'm tired. Mr.
Stop
O'Shea.
interrupting me, Mr. Lester.
Shit. Damn. How did this, man?
Pretrial is adjourned to February 7th at 8:15 a.m. Mr. Lester has made a request for a personal recognizance bond. Court has addressed the issue of bond with Mr. Lester numerous times previously. My decision on bond and reasons for it at this point have not changed.
Supposed to be professional. Racist.
Mr. Lester currently has a
Too expensive, sir. Too expensive.
Mr. Lester currently has a $5,000 cash or surety bond in this case, and that is appropriate, in my opinion, to assure his further appearances at this court. And so I'm going to deny the request for a personal recognizance bond.
That's crazy. Because I ain't white. Mr. Margosian.
Mr. Lester. All right, you know what, Mr. Lester, stop.
No.
I muted your device, Mr. Lester. You have been warned repeatedly by me in this hearing as well as in other hearings. You are in contempt of this court as a result of your behavior here today. It's a sentence of the court that you served 93 days in the Lenawee County Jail. There's no further information that the court needs to find the contempt. It was directed in the presence of the court and after being warned numerous times. So, Mr. Lester, you can let the officer that's with you know that you are done with court for today. I will put the device in the waiting room until you are gone. Can you call the jail and let them know we're ready for Mr. Young? I did not have anything else for you, Mr. Dagger Margosian.
Your Honor, do you have Lucas Tucker on your docket for today?
Oh, you know what? I did. I'm sorry.
Young, please. We are all done with Mr. Lester. Thank you.
And, Your Honor, just administratively on Mr. Lester, do you need our office to do anything, or, I mean, obviously our.
Just process of sending it to Mr. Castleberry for
That's what
a
I
new
figured.
appointment. Yeah.
That's okay. Will do. Thank you.
Okay, and so Mr. Tucker is not logged in. Have you had any communication with it?
Unfortunately not, Your Honor.
All right, we are on the record in file 23-21414-FH, People versus Lucas William McGraw Tucker. We are here today for a pretrial conference. In this case, we are proceeding today partially by video conference and partially in person. First, going to have the attorneys place their appearances on the record.
E.B. McClarmy of the People.
Michael Dagger Margosian for Mr. Tucker.
All right, the record should reflect this matter was set for hearing at 8:15 a.m. this morning. It's now 10:42 a.m. and Mr. Tucker is not logged into the Zoom session, nor is he present here in the courtroom. Mr. Dagger Margosian, anything you want to say with respect to that issue?
No, Your Honor.
I do not see any previous failures to appear in this case, so I am going to wait 48 hours to see if we hear from Mr. Tucker. If we haven't heard from Mr. Tucker within that 48-hour grace period, I will revoke and forfeit his bond at that time and issue a bench warrant with a bond on the bench warrant in the amount of $25,000 cash.
And Judge, I have in my notes that we had a pretrial that he did not appear at on December 13th and December 27th. Does your file reflect whether he was here or not those days?
Let me look at the section. On what days?
December 13th and December 27th. Those were our last two pretrials.
Court notes indicate that he did not appear on the 13th, but that he was here on the 27th.
Okay,
But we do have the prior failure to appear on the 13th. So that being the case, he would not be entitled to that 48-hour grace period. And so I will proceed to issue that warrant and revoke and forfeit bonds today. Okay, anything else we need to address with this case today?
No, thank you.
no,
Okay.
thank you.
Thank you. All right, we have Mr. Young here now. Mr. Malero.
Judge, may I have a breakout with Mr. Young real quick? Well, probably won't be real quick, but I do need one.
Yeah, 1 second.
And so then, do the process.
Who's your prosecutor?
Everything all right, Judge?
Yeah,
Oh, okay.
are you ready to go on the record?
No, we didn't do a breakout.
Oh, I'm sorry. I was looking at my other screen and not realizing what happened.
Thought I was getting a timeout or something.
Okay. All right, are we ready to proceed, Mr. Malero?
Yes, we are, Your Honor.
All right, we are on the record in file 23-21305-FH and 23-21306-FC, People versus Eric Michael Young. We are here for a final pretrial in the filing 305 and a pretrial in filing 306. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung, appearing for the people.
Salvatore Malero on behalf of Eric Young.
Okay, and Mr. Malero, where do we stand with Mr. Young's cases today?
Your Honor, I believe we have reached a resolution. I'm going to place that on the record. If I am mistaken in anything, I'm sure Mr. Hartung will provide clarification. So, Your Honor, on the 305 file, Mr. Young will be pleading no contest to count 1. On the 306 file, Mr. Young will be pleading no contest to a CSC second with a supplement, 1 supplement, and he'll be pleading guilty to the supplement or habitual notice. So it's no contest to the facts, a guilty on the supplement. We have a Killebrew agreement of Mr. Young will receive a sentence of 8 years on the minimum. And then we have a request on bond conditions after the plea is entered. I think that.
All right.
Oh, and the count 1 is a 15-year felony, and the CST second is a 15-year felony.
Okay, Mr. Hartung, is that a complete and accurate statement of the plea agreement?
I believe it is. I just want to make sure on the record that the sub that he will plead guilty to is for both files. So
Okay,
he'll create.
that's fine, Judge. Or, I mean,
He'll
that's,
create a 22.5-year cap on the top end. We've agreed to an 8-year sentence on the minimum. The victims' families have approved this. And these sentences would run concurrent.
yes, that's right. Sorry, concurrent. Yes.
Okay, so
Yes, that
the
is correct.
supplement is, I'm sorry, what was that again? It's a second offense?
It would be a second offense, so it would increase it by 7.5 years on each file for this particular plea.
Okay, Mr. Young, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yeah.
You are Eric Michael Young?
Yes.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 23-21305-FH? I'm sorry, plead no contest today in that file to 3rd-degree criminal sexual conduct?
Yeah.
Is it also your intention to admit a second habitual offender notice?
Yes.
Do you understand that with respect to that charge, then the maximum possible penalty would be 22.5 years in prison?
Yeah.
With respect to the 23-21306-FC file, is it your intention to plead guilty to count 2 criminal sexual conduct 2nd degree? I'm sorry, I was not able to hear your answer.
Yeah.
And is it also your intention to admit a second habitual offender notice in that file as well?
Yeah.
And do you understand that with that second offense notice that the maximum possible penalty for that charge would again be 22.5 years in prison?
Yeah.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yeah.
Do you wish neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court other than as we've discussed it on the record here this morning? Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Malero?
That is correct, Judge.
Is that also your understanding, Mr. Young? I'm sorry, the microphone there is bad. Was that a yes?
Yeah. Yeah.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Young, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Sorry, I wasn't able to hear what you said.
Yeah.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yeah.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand, Mr. Young, that by entering a plea to these offenses that you will be required to register under the Michigan Sex Offender Registration Act? Sorry, the microphone didn't catch your voice again.
Yeah.
How do you wish to plead to the charge in file 23-21305-FH that on or about June 10, 2022 in the city of Adrian, county of Lenawee, that you did commit the offense of criminal sexual conduct, 3rd degree?
That would be no contest, Judge.
Okay, so Mr. Young, if you want to plead no contest, you need to say no contest. Sorry, the microphone's there, not good there.
Contest.
Can you try sitting a little closer to the device?
No contest.
Okay, thank you. And in file 23-21306-FC, so I don't have years on this.
This is the one that we amended and filed with the court and gave to Mr. Milaro yesterday.
Oh, I'm sorry.
That's okay. You may not have received it yet. I can put those dates on the record if you'd like me to.
Go ahead, please do.
It is December 1st of 2013 through December 31st of 2015 for counts 1, 2, and 3. And then count 4 was the June 10th of 22 date.
Okay. So Mr. Young, how do you wish to plead to the charge that on or about December 1st, 2013 through December 31st of 2015? And I'm sure it doesn't have city, township, or village in my information.
That's Adrian City.
In the city of Adrian, county of Lenawee, that you did commit the offense of 2nd degree criminal sexual conduct. I was not able to hear anything there. Sorry, can you try one more time?
No contest.
Okay. Has anyone made any threats or promises to you to induce you to plead no contest to those charges? I need you to sit closer to the device. It's not getting your voice.
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Young to plead no contest?
No, Your Honor.
Judge, I think we should probably add that all remaining charges would be dismissed at sentencing. Other than that, there are no other inducements other than it's indicated on the record.
And I presume you're in agreement with that, Mr. Hart?
That's accurate.
Okay. Mr. Young, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead no contest today?
Yeah.
All right, Mr. Malero, would you like to review the factual basis?
Sure.
I can do that if you prefer, Mr. Malaro.
Yeah, I would prefer Mr. Harton do it.
Okay.
That's okay with the court. I'm going to summarize the testimony of the two minor victims from the preliminary examination that was held before Judge Morgan on March 16, 2023. In file number that ends in 305 FH, the minor witness, whose initials are GW, who was 15 years old at the time of the incident, testified that she was digitally penetrated by the defendant, Eric Michael Young, at a residence on Budlong Street in the city of Adrian, Lenawee County, Michigan, and that the assault happened over a period of time in the house that Mr. Young was living at on Budlong Street. And in file number 306, with the dates between 12/1/13 and 12/31 of 2015, the minor victim, who was at age 8 at the time of this particular incident, testified that she also was digitally penetrated by Eric Michael Young in her bedroom on Treat Street in the city of Adrian, Lenawee County, Michigan, during that time frame. Both of these young victims testified, and their mothers testified as well, that the defendant had a romantic relationship or had a romantic relationship with each of the mothers and made access to the minor children through that avenue.
All right. Mr. Malero, do you agree that that satisfies the factual basis?
I would agree, Judge.
Right. Has the court complied with MTR 6.302 B, C, and D, Mr. Harton?
On that part of the plea, yes, Your Honor.
Oh, and I apologize. So we need to review the habitual offender. Mr. Young, do you agree that on or about February 18, 1998, you were convicted of felony breaking and entering into a building with intent in the 37th Circuit Court, that's Calhoun County, Michigan?
Yes.
Do you also agree that on or about November 6, 2013, that you were convicted of possession of a controlled substance, cocaine, heroin?
I'm sorry, do we only need to do one?
Oh, I apologize. Yeah.
We're only doing one, but we're only taking it for one, Mr. Malaro.
Right.
Okay.
Oh, are you gonna do one for each, I take it? Is that what we're doing?
They apply to both files.
Yeah, I think the one conviction can apply to both files, so I think
Yeah,
we're all
okay.
set.
Thank you, Judge.
My eyes were on the notice that I had, so
That's right. You had a tough morning, Judge.
no need for additional. All right, so I'm sorry, has the court complied with MCR 6.302 B, C, and D, Mr. Harton?
Yes, Your Honor.
Mr. Malero?
Yes, Judge.
All right, I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Young has had full knowledge of his rights and he's had competent counsel. Other than, as we've discussed on the record here today, of course, not made any other agreements regarding the possibility of plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department and set sentencing for March 8th at 8:15 a.m.
Judge, two other matters, if I may.
Yes, go ahead.
First, Mr. Young would request to be present in person for his sentencing. And the second request is Mr. Young's asked me to request of the court that he be granted a PR bond pending sentencing so that he could spend that time with his family. He has I think a 9-year-old son that I think this court might be familiar with, is engaged in a considerable amount of parenting time litigation, and he would like to spend some time with his son prior to the sentence being imposed. That's our request.
Mr. Hartung, people have a position.
We would obviously oppose that request, Your Honor. It's only a very short period of time between now and the time of sentencing, and he's looking at a rather lengthy prison term.
All right. At this point, we do have convictions on two very serious crimes, and those are going to carry with them prison sentences. And at this point, I don't feel, based on that it would be appropriate to release Mr. Young on a PR bond. So I'm going to deny that request.
All right, thank you, Judge.
Thank you, Your Honor.
Mr. Young, you can let the officer that's with you know that you are done with court for today, and we will make arrangements to have you in person for the sentencing.
All right, great.
Thank you, Eric.
And call for Mr. All right, and we are calling for Mr. Choate right now.
Thank you,
Hi,
Judge.
it's Linda. Could we have Kyle Schultz, please? Thank you.
One.
Not really.
Mine's long.
Well,
Okay, Mr. Malero, do you need a breakout session with Mr. Choate?
I do not, Your Honor.
Right. We're on the record in file 23-21435-FH, People versus Kyle James Choate. We are here today for a pretrial conference in this case, and we are proceeding today by video conference and also in person. First, let me have the attorneys place the appearances on the record, beginning with Ms. McClure.
Evie McClure, we have the people.
Salvatore Malero on behalf of Kyle Choate.
All right, and Mr. Malero, where do we stand with Mr. Choate's case today?
Your Honor, been trying to resolve this with Mr. Sneed. He's the prosecutor on the matter, but we have not yet finalized anything. And as the court noted last week, the case is old. So if we could set this for trial, I will have a resolution by then. Before then.
Okay. If it does get tried, do you have any sense of how much time we'll need?
I'd say like 1 day.
Francis, could we have a 1 day jury trial date, please?
Yes.
Tuesday, April 16th at 9 a.m.
That works for the people.
April 16th is fine, Judge.
Do a final pretrial then on April 10th. At 8:15, and court will issue a scheduling order. Is there anything else that we need to address today?
No, Your Honor. Kyle, as soon as I get this worked out, I'll be over to talk to you, and then we'll get it in front of the judge, okay? We're close. We're close. We're just not there, Kyle. Thank you, Judge.
Thank you, Mr. Choate. You can let the officer that's with you know that you are done with court for today. I believe that is everything.
Yay. Thank you, Judge.
Thank you.
Have a nice day.
Yep.